Today we will discuss the criminal codes. What are criminal codes and for what they meant for? सबसे पहले तो ये समझ लें कि क्रिमिनल कोड क्या होते हैं और क्यों बनाए गए. So the basic requirement of criminal code is to deal with the offenders who committed the crimes. जिसने क्राइम किया है, जिसने अपराध किया है, उसे सजा मिलना चाहिए और उस सजा को देने के लिए क्रिमिनल कोड कॉन्स्टिट्यूट किए गए हैं. अभी तक सीआरपीसी में चल रहे थे. सीआरपी मीन्स कोड ऑफ क्रिमिनल प्रोसीजर. लेकिन अब 1 जुलाई 2024 से बीएनएसएस भारतीय नागरिक सुरक्षा संहिता लागू हो गई है. तो बीएनएसएस अब सीआरपीसी को रिप्लेस कर दी. सो नाउ सीआरपीसी हैज बीन रिप्लेस्ड बाय बीएनएसएस. नाउ what are the criminal codes? Again the question is, so criminal codes are the codes constituted to deal with the offenders and to punish them. So the basic object is to give the justice to the offenders as well as to the victims, to the society. So this is the basic thing. Now, what are the classes of criminal codes? Section 6 of CRPC as well as newly implemented BNSS suggests that Section 6, what Section 6 provides? That beside high courts and courts constituted other than this code or Sanhita. Previously it was this code and now it is this Sanhita. So besides high courts and court constituted other than this code or Sanhita. So there are two things. Number one, beside high courts, what does it mean? Beside high court means whether high court is included or not. So the term besides means high court is there. So high court is the criminal court. Now the beside high court के अलावा और कौन कौन से कोर्ट्स हैं? Other than the court constituted by laws other than this code or this Sanhita. So the court not constituted in this Sanhita means in BNSS or previously in CRPC, right? So court not constituted are also the criminal courts if they are constituted for special purposes, like the court constituted by the Electricity Act, the court constituted by the SC/ST Prevention of Atrocities Act, court constituted by NDPS Act. So these are the criminal courts constituted by other acts. Now this other than these courts means high courts are there. Yes, of course, high courts are criminal courts. Other than the high courts, other courts constituted by the laws other than this code or BNSS. इस संहिता के अलावा या सीआरपीसी के अलावा अगर किसी और कानून में कोई कोर्ट कॉन्स्टिट्यूट किए गए हैं तो वो कोर्ट भी क्रिमिनल कोर्ट होंगे. हाई कोर्ट तो क्रिमिनल कोर्ट है ही. अदर देन दिस कोर्ट्स, ये कोर्ट या बीएनएसएस और सीआरपीसी दोनों कौन कौन सी कैटेगरीज डिफाइन करती हैं? देयर आर वेरियस कैटेगरीज. नंबर 1, कोर्ट ऑफ सेशन. कोर्ट ऑफ सेशन. नंबर 2, जुडिशियल मजिस्ट्रेट ऑफ फर्स्ट क्लास. फर्स्ट क्लास जुडिशियल मजिस्ट्रेट, popularly known as JMFC, and judicial magistrate second class. And another category is executive magistrate. फर्स्ट कोर्ट ऑफ सेशन, हिंदी में उसे हम कहते हैं सत्र न्यायालय. सो कोर्ट ऑफ सेशन और कोर्ट ऑफ सेशन जज. सो दिस सेशन is defined in section 7 of CRPC as well as BNSS, in which it is specifically mentioned that the court constituted under the state government may divide the states in various session divisions स्टेट को अलग अलग सेशन डिवीजन में बांटेगी स्टेट। यूजुअली प्रैक्टिस क्या है? एवरी डिस्ट्रिक्ट शैल बी अ सेशन डिवीजन, इट इज प्रैक्टिस। सो यूजुअली डिस्ट्रिक्ट कॉन्स्टिट्यूट्स द सेशन डिवीजन। तो सेशन डिवीजन में एक सेशन जज होगा। एंड व्हाट इज डिफरेंस बिटवीन डिस्ट्रिक्ट जज एंड सेशन जज? So district session judge or session court is the position for criminal matters. And what is the district judge other than the criminal matters? If any judicial officers who is a session judge for a session division will be district judge for the same district for the matters other than the criminal matters. तो उसी जिले में उसी सेशन डिवीजन में वो जज सेशन जज हो सकता है और वही जज डिस्ट्रिक्ट जज भी हो सकता है और यूजुअली होता भी है। लेकिन जब वो क्रिमिनल मैटर डील करेगा एट दैट टाइम ही विल बी सेशन जज, अदरवाइज ही विल बी डिस्ट्रिक्ट जज। सो डिस्ट्रिक्ट एंड सेशन जज, we usually use term district and session judge. So one class is high court, second class is court of session. Now the third class, the court of magistrate, and we discuss the judicial magistrate of first class and judicial magistrate of second class. So these two classes of magistrates are there in the CRPC. But in practice, some of the judicial magistrates have been appointed or usually appoint as the chief judicial magistrate or additional chief judicial magistrates. So chief judicial magistrates and additional chief judicial magistrates are magistrate of the first class, and second category is the judicial magistrate of the second class. Now the term additional, because when we talk about the session judge, so there are a number of additional session judges also. If session judge is there, then additional session judges are also there. So what is difference between session judge and additional session judge? So difference between session judge and additional session judge is simple difference. That is the administrative difference, because all the session judges are having the judicial power at the same power which the session judge has. जो पावर सेशन जज की होगी बिल्कुल सेम जुडिशियल पावर्स एडिशनल सेशन जजेस की होगी। सो जहां भी हम एडिशनल टर्म यूज करते हैं, जस्ट कीप इन माइंड व्हेन वी आर यूजिंग टर्म एडिशनल मींस द पर्सन विद द सेम पावर, with the same authority. But since one person can't complete the work of entire work allotted to him, then additional person shall be appointed to conclude or to complete those work. So, suppose in a session division there are 500 cases in a year. Whether a person can do it? A person can't handle more than 100 cases in a year. So, to deal with them, the 5 additional session judges are required. So these 5 judges will have the same judicial authority, whereas the session judge will be administrative head. Now the chief judicial magistrate, so it is another class. The magistrates, so all the magistrates, the appeal from the order passed by any magistrate shall be preferred before the court of session. So court of session is the appellate court for the court of magistrates. When we talk about the judicial magistrate specifically, chief judicial magistrate, additional chief judicial magistrates, and first judicial magistrate first class, these 3 classes are the same. These 3 classes are the magistrate of the first class only. And the second class is the judicial magistrate class 2, class 2nd. So these are the judicial magistrate. Now another class is also provided there, that is executive magistrates. So who are the executive magistrates? Executive magistrates are the state government officials appointed to handle the law and order of a particular area. So, those magistrates are empowered with the magisterial power to deal with the emergency situation and for preventive powers. So, there are executive magistrate and judicial magistrate. How can we differentiate them? Just think of the highest executive magistrate is DM, the district magistrate, whom we popularly known as collector in various states, deputy commissioner in some other states, and even with the name of DM in some states. So district magistrate is the highest executive magistrate, and all the executive magistrates are subordinate to DM, subject to subordination of the state government, whereas all the judicial magistrates are subordinate to session judge, subject to final subordination to the High Court. All the judicial magistrates are subordinate to session judges, subject to subordination of High Court, not the state government. Whereas the executive magistrate are subordinate to district judge, district magistrate, subject to final subordination of the state government. So, the executive magistrates are the state government servant, whereas the judicial magistrate are part of judicial. Now, what is difference in function of those two authorities, executive magistrate and judicial magistrate, right? So, executive magistrate having mainly preventive actions. They have the preventive powers, other than some other power specified in the Bnss, like granting license, suspending license, giving permissions, these kind of executive work. Whereas the judicial magistrate usually sits in the court only. Usually sits in the court only. They decide the case brought before them. उनके सामने जो केस आएगा उसमें वो डिसाइड करेंगे, उसमें वो ट्रायल करेंगे, ट्रायल करने के बाद या तो इंक्वायरी करेंगे, ट्रायल करेंगे और उसके बाद केस डिसाइड करेंगे. Simply, in simple words, we can understand that work of executive magistrate is preventive work before the commission of the offence. Once the offence has been committed, then except some specific circumstances, the work of judicial magistrate begins. This is the Lakshman Rekha between these two magistrates. Like executive magistrate has nothing to do after the commission of the offence. Once the offence has been committed, then executive magistrate has limited scope to present the person before the judicial magistrate. That's all. Or even in some cases, collection of evidences, or even recording some statements, like that only. But the judicial magistrate has the authority to deal with all the matters after commission of the offence. He will punish the person for commission of the offence. But executive magistrates have no power after commission of the offence. But if he has suspicion or he has ground for suspicion that some person may commit an offence, he can take the preventive action at that point. So, executive magistrate has the authority to take preventive action, and in some cases, some specific cases, he may have the power even after commission of the offence or in suspicion of the offence. But the case shall be decided by the judicial magistrate only. The judicial magistrate may send the person to the jail. Judicial magistrate can send the person to the judicial custody, to the police custody, to remand. So usually the pass lies with the, after commission of the offence, with the judicial magistrate, except some exceptional circumstances. So this is the difference between judicial magistrate and executive magistrates. Now the uh, court of session. Court of session has the jurisdiction to give any sentence provided in law. Judicial magistrate may award any sentence. Since executive magistrate has no power to award any sentence to anybody, because their action is preventive action only. So the court of session or the judicial magistrate may award the sentence. So what is the jurisdiction? Up to what extent the court can award the sentence? Like a court of session. Court of session may punish any person with any sentence provided by the law. Any punishment provided by the law. But the limitation is that that sentence shall be confirmed by the High Court. Unless it is not confirmed by the High Court, that shall not be executed. Now, the additional session judge, as I had said earlier, that additional will have the same power what the original authority is having. So जो पावर सेशन जज के पास है वही पावर एडिशनल सेशन जज के पास भी होगी. लॉ में प्रोवाइडेड कोई भी सेंटेंस दे सकता है इंक्लूडिंग डेथ सेंटेंस, बट डेथ सेंटेंस के केस में उसे हाई कोर्ट से कंफर्म करना जरूरी होगा. नाउ magistrates. So there are two classes of magistrates: judicial magistrate class 1, judicial magistrate class 2, provided in the CRPC. Whereas it has also been provided that some of the judicial magistrate first class shall be empowered with the power of chief judicial magistrate or additional chief judicial magistrate. So let us begin with the judicial magistrate class 2. The judicial magistrate class 2 may sentence with fine up to rupees 10,000 according to Bnss and imprisonment up to 1 year. Fine up to 10,000, imprisonment up to 1 year. Earlier in CRPC, the fine was up to 5,000 and imprisonment was the same, that is 1 year. Now in Bnss, fine have been raised up to 10,000 and imprisonment up to 1 year. It is same. Now the judicial magistrate first class. Judicial magistrate first class are having the power to impose a fine up to 50,000 in Bnss, which was 10,000 earlier in CRPC. So according to CRPC, the fine, the authority of judicial magistrate class 1 to impose a fine up to rupees 10,000, which has been now raised up to 50,000 in Bnss. But the imprisonment he may impose is the same. He may sentenced to imprisonment up to 3 years. 3 साल तक की सजा जेल की दे सकता है. 3 साल जेल की सजा दे सकता है जुडिशियल मजिस्ट्रेट फर्स्ट क्लास, और जुडिशियल मजिस्ट्रेट सेकंड क्लास 1 साल तक की जेल की सजा दे सकता है 10,000 रुपए फाइन के साथ. नाउ CJM or the same power having by the ACJM, additional CJM. So the CJM is having the power to impose fine, any fine, up to any extent, subject to provision of law. इसका मतलब लॉ में जो मैक्सिमम फाइन दिया गया है उस तक वो दे सकता है. लॉ में जो भी फाइन दिया गया है किसी पर्टिकुलर एक्ट के लिए, किसी पर्टिकुलर ऑफेंस के लिए जो फाइन दिया गया है उस फाइन को वो इम्पोज कर सकता है. कोई भी फाइन जो लॉ में प्रोवाइड किया गया है। लेकिन इम्प्रिजनमेंट यानी जेल की सजा, उसकी एक लिमिटेशन है। ही कैन गिव द सेंटेंस अप टू 7 years इम्प्रिजनमेंट। जेल की सजा केवल 7 साल तक की दे सकता है। सो आई एम रिपीटिंग अगेन द डिफरेंस बिटवीन एग्जीक्यूटिव मजिस्ट्रेट एंड जुडिशियल मजिस्ट्रेट। एग्जीक्यूटिव मजिस्ट्रेट कौन है? जिनका प्रिवेंटिव एक्शन है। जुडिशियल मजिस्ट्रेट कौन है? जिनका क्यूरेटिव एक्शन है। ऑफेंस कमिट होने से पहले अगर कोई एक्शन लेना है तो वो लेगा एग्जीक्यूटिव मजिस्ट्रेट, और अगर ऑफेंस कमिट हो गया है तो एक्शन लेगा जुडिशियल मजिस्ट्रेट। सो इट्स एनफ फॉर दिस क्लास। थैंक यू।